Well, hello once again, my friends, my fellow historians, and my fellow lovers of the SS United States. I'd like to welcome you to another video, and this video is for today. This is January 22nd of 2026. I do have an update on the docket. That's in a response. My last update was January 7th of 2026. Since then, they have made in addition to the docket, on January 7th, that was made after my video, that would be document number 41. And it's all it basically is. It's really short. The time commenced 1 p.m. The time concluded 2:18 p.m. Present via Zoom for Plaintiff New York Coalition to Save the Steamship United States Incorporated, James Maloney, Esquire, Law Office of James Maloney, Port Washington, New York. Present for Defendant, OKALOOSA County, Florida, Matthew SHAUD, Esquire, Nabors, Giblin, and Nickerson, Pennsylvania, Tallahassee, Florida. The proceedings, 1 o'clock p.m., court was in session. Oral arguments by Mr. SHAUD and Mr. Maloney on a defendant's motion for sanctions and incorporate memorandum of law, which was EDF 31. At 2:18 p.m., the court will take argument of counsel against the advisement and issue a written ruling. Court is adjourned. So basically, that was building up to this. Now, this was updated on January 20th of 2026, and this is document number 42. This is the order. Defendant's motion for Rule 11 sanctions, referring to document 31. Incidentally, document 31 was introduced to the docket on Tuesday, August 19th of 2025, and that was the motion for sanctions and incorporated memorandum of law by OKALOOSA County, Florida, and that was entered by Matthew SHAUD. Well, that was denied, so the plaintiff's unopposed motion to take judicial notice in document 38, which was introduced on December 23rd of 2025, and that was the consent motion to take judicial notice, Re 31, motion for sanctions and incorporated memorandum of law by New York Coalition to Save the Steamship United States. And that was terminated as moot, signed by the magistrate, Judge Hope T. Cannon, and this was on January 20th of 2026. Now, when we go ahead and we open up document number 42, this is 14 pages. I'm not going to read it word for word, but I am going to read you the important parts. When it comes to the order, this matter is before the court on Defendant OKALOOSA County's motion for sanctions under Federal Rule of Civil Procedure 11, Document 31. Upon consideration of the motion, plaintiff's response, Document 32, and with the benefit of oral argument, the motion shall be denied. They go into the background. I'm not going to read all the background to you because basically all the videos have been building that up. We go to part 2. This is the legal standard. Rule 11 imposes an affirmative duty to the attorney to conduct a reasonable inquiry into both the facts and the law before filing a pleading or motion. So when we go down to the discussion part, the county argues the coalition's amended complaint is objectively frivolous because 1, the coalition should have known it could not establish a standing, or count 1 had no reasonable chance of success because the coalition could not cite an existing cause of action in support of it, and 3, the count 2, the coalition's counsel was deliberately indifferent to obvious facts when he filed the plaintiff's amended complaint raising count 2. See document 31. The county asserts that the coalition's counsel failed to make an inquiry reasonable under the circumstances before filing. and that, as to the coalition's argument under the National Historic Preservation Act, any competent attorney conducting a pre-filing investigation would or should have determined that the county could not be liable for violations of the NHPA, for the county is not a federal agency. The county further argues the coalition's amended complaint was filed in bad faith for improper purpose because the lawsuit's only purpose was to delay and prohibit the county from using its property, and the coalition concedes its request was unprecedented. The county argues a plaintiff's persistent bad faith and dilatory tactics are wholly improper and a gross abuse of this court's finite resources. In its written response, the coalition takes issue with the timing of the motion, contending that it assumed the motion was off the table when the county did not file it after the expiration of the 21-day safe harbor, and instead asked the coalition to consent to allowing the county to file a reply to the coalition's response to the motion to dismiss. The coalition also argues the motion is moot because once it was contracted by the county prior to the filing of the motion in August, the coalition filed a notice of voluntary dismissal with prejudice under Rule Number 41, giving the county exactly what it was asking for. Additionally, the coalition argues the action was not frivolous because the concept of Article 3 standing has not been defined with complete consistency in all the various cases. The concept cannot be reduced to one sentence or one paragraph definition. Indeed, at the hearing, the coalition's counsel argued that despite the Gardner and Ladies memorandum decisions, the Supreme Court has been much more lenient when it comes to standing. Coalition counsel conceded at the January 7th hearing that he knew from the beginning that there may be issues with the coalition's standing. He nonetheless asserted that the coalition's standing argument was not frivolous because reasonable minds can differ as to standings. Additionally, the coalition put a great deal of effort into amending its complaint to present non-frivolous standing argument after the first motion to dismiss was filed. And finally, the coalition argued that there was no bad faith nor an improper purpose to the litigation, and the coalition's purpose was not to harm the county in any way. It was to save the vessel, that is an icon of American history, from being sunk. Counsel noted that were he to be sanctioned under Rule 11, he didn't think he would ever take a chance again to try to do the right thing and save the ship. That's something special. This is a sui generis case. While the court agrees with the county that the 11th Circuit and the court's decision in Gardner and Ladies, I should have given the coalition great pause in bringing this action. The court does not think sanctions beyond dismissal are warranted in the case. The document goes on to read, as the coalition readily admits the case was brought to try to save the SS United States from being sunk to the bottom of the ocean. While the coalition's emotional connection to the ship was perhaps a tie that carried them beyond the sea of effective advocacy for their cause, Rule 11 sanctions are an extraordinary remedy that must be exercised with extreme caution. As the court stated in TriStar Prods Incorporated, Rule 11 sanctions should not operate to chill attorneys' legitimate enthusiasms and creativity in advancing legal and factual theories. While the coalition may have ultimately been unsuccessful in its efforts, the court is unable to find that the coalition's conduct in filing this suit constituted the sort of egregious, abusive, bad faith conduct required to trigger sanctions or an award of attorney. So finally, after all that, in conclusion, accordingly, it is ordered: 1. The defendant's motion for Rule 11 sanctions, Document 31, is denied. And 2. The plaintiff's unopposed motion to take judicial notice, Document 38, is terminated as moot. This was done and ordered on this 20th day of January of 2026 by Hope Ty Cannon, United States Magistrate Judge. So again, this was document 42, and this was filed on January 20th of 2026. And that is where we stand right now. That's the latest update on the docket. If there are any other updates, I'll sure to be bringing it to you. I thank you so much for watching. Until my next video on the ship herself or the docket involving her, I thank you for watching, and I'll talk to you soon.